We had in our 10 Commandments the golden rule, and that is, do unto others as you would have them do unto you. And that phrase is actually called the universal ethic. It goes back 5,000 years. And I've always thought it didn't work very well, because it assumes that everybody wants the same thing. I change it in this context of civility in the courtroom to do unto others as you would have the judge do unto you. Okay? So that means, once again, know your judge and know what you should be doing in front of the judge. And if you don't know, ask someone. And if you want to make statements to embarrass the court will at times embarrass you. And we've seen it in writings, a joke on the board about welcome to kindergarten court. If you want to act like a kindergartner, the judges will treat you. That's how I changed to do unto others.
And again, that ties in a bit to what David was saying about situational awareness. Know your judge, know your court, and just like you expect that judge to be prepared in hearing your argument, you too should be prepared so he or she can hear it. Punctual. If court starts at 9 o'clock, what time should you be there? You said 8:30. You're my hero. Yes, that's the right answer. Be there early. Why should you be there early? Make sure, if it's an evidentiary hearing, your witnesses are there, because you will be charged with their conduct. It gives you an opportunity, if need be, to talk to the other attorney and work out any last-minute details that may need to be done. It also, if nothing else, allows you some time just to decompress. As an attorney, one of the most nerve-wracking things I have is running into a courtroom and just trying to get my bearings. In our state, we are statewide. We could be in North Jersey in the morning and at the tip of South Jersey in the afternoon. Trying to get my bearings on that court and get an understanding of how that judge wanted things done in his or her courtroom. If nothing else, it gives you a chance to kind of calm down, be prepared, maybe look over your papers if you were watching the Giants game last night, but to be ready that when you go to counsel table, you are ready to go and not wasting your time, your adversary's time, or as important, the court's time. Also, dress. I don't know about how things are in New Mexico. In New Jersey, we're still a suit and tie for men. Business dress, I guess it would be called, for female attorneys. Now, in New York, it's my understanding in certain jurisdictions, a purple crushed velvet tuxedo, as in my cousin Vinny, is appropriate attire. That would be Queens and Staten Island, I believe. But it's usually not in most jurisdictions. Folks, dress appropriately. In New Mexico, remember the tie rule. Always keep the tie up, or you may be subject to one of these presentations. Female attorneys, when that was in court, a young attorney goes to the podium, to the waist, business suit, the whole 9 yards, looking in the business attire. Then I look. She had on a fake calfskin skirt. Now, this is New Jersey. You might get away with it out west, but New Jersey, the calfskin, the judge was kind of looking on top of white leather boots. She was called up by the judge and said, I'm going to let the cow and the leather boots go today, but next time you're here, try something a little more stately. Just because you may be comfortable wearing it, men, those for you too, watch your color combinations, watch your funky shoes. Men, we have a tendency to have really funky shoes. Juries tend to pick up on that. If they don't want to spend enough time to polish their shoes, did they spend enough time in preparing their client's defense? And we've done that in mock trials, where we had a mock trial, this young attorney, and I got to play judge, who was great, by the way. That is a great kid. I'm like, this kid's doing all right. Good job. We polled the jury, who were a group of state workers who got 3 hours out of their schedule to come play juror. And we asked, why did you rule against him? We're unclear. Look at his shoes. He didn't take time to polish his shoes. And they felt they were being disrespected by his lack of preparation. Now again, that's an extreme example, but you never know what's going to annoy a jury or a judge.
I've already heard 3 times that I should be wearing a tie this morning, so I apologize. When I asked, what are you tie for this? Oh, no. In Arizona, and I don't know if you have this too, but we have an official tie. We have a state tie. bolo tie. Is this thing here too? Is it?
Yeah. He stole it from us.
Oh, invaluable. And so religiously, I wear mine on Fridays, and I have about 5 or 6 of them, so I rotate them around. And it's very important. In Arizona, though, where it's 115 for about 30 days a year, we kind of relax jackets. We'll have short sleeves, but appropriate attire is necessary. We had one AG a long time ago come in with a sundress with Spanish wraps and sandals, no hose. And we thought she was going to a garden party maybe and suggested that perhaps she'd be more properly attired next time she comes back. Which she did. She said, "Is this federal court?" I said, "No, it's not."
Okay, and this relates back to something Mary Jo alluded to and also the judge earlier. When you're making your verbal or written submissions, stick to the facts, folks. Watch the ad hominem attacks. Your Honor, are we going to again be subjected to my adversary's profound lack of understanding of the legal process and all that it entails in these arguments based on minutia, vindictive, and innuendo? Come on, I don't know about you, but even in New Jersey, that's going to cause a judge to get upset. It's usually going to lead to a hostile exchange between counsel and disrupt the proceedings. Address the argument. The defense mistakenly asserts you're taking that personal aspect out of it, yet what? Making clear that the other side's argument is not based soundly on the facts and the law. Always take the personal out, attack the argument, not the person making the argument. Address your remarks to the court, and this is incredibly difficult, especially when you're fired up, your adversary's fired up, your client's looking at you like, what the heck, did you really pass the bar? Which was a very familiar refrain when I was practicing. That was one of the questions, except the fact I did pass the bar. I went into a few, but I did pass the bar that I had to pass. Now, with respect to that, I managed, and it was through a lot of practice, to get into the habit of never looking to my right or left, depending on which side of the courtroom I was on, and always looking to the front. Even if I was addressing my adversary, it at least gave the court the appearance and those in the court that I was directing my comments to the judge and certainly not to my adversary. Few things will upset a judge more than if you make that judge feel like he or she is peripheral to the proceedings in front of them. Also, don't interrupt counsel if you don't have to. You've had your chance, or you will get your chance to make your argument. This is especially so, and I've seen it with attorneys, and I automatically cringe. Counsel for the other side is making their opening statement or their closing argument. Objection, Your Honor, on something that is not truly worth the objection to begin with. If it's a fundamental issue, deal with it in limine beforehand. You can pretty much anticipate where your adversary is going, but to interrupt reduces the proceedings down to, again, that playground mentality of he said I did this and I didn't do that. No judge in his or her right mind is going to want to entertain that type of discourse.
The more I have to deal with that sort of distraction, the ad hominem arguments, the personal attacks, the less I'm able to pay attention to what the real outcome should be. Okay. If I have to divert my attention for all these things, a senior partner told me when I first started practicing law, it's going to take me hunting. We're going to go quail hunting. And I said, quail hunting? Again, somebody's putting a shotgun in my hand, guy from New York City. Guns. He said, when you go hunting for quail, you don't shoot at rabbits. I said, what does that mean? He says, we're going to be out there for about 5 or 6 hours. You're not going to see a quail for probably about 2 or 3. He said, but you're going to see a lot of rabbits. Those rabbits are going to jump up, and you're going to be so itching to shoot one that you're going to raise that shotgun and go after it. He says, well, what are you here for? You're here for quail. You're not here for rabbits. You eat rabbits, they'll kill you. They've got all kind of crazy things. The quail are good. So it was kind of a philosophical bent on, do you really want to tie yourself up to something you're really not here for? So it doesn't get you what you want. Again, being effective. Where's your focus? And if somebody ever asked me for an extension of the page limitation when we have 2 pages of ad hominem text, You can imagine what my response is. No, you won't have.